Well, Public Enterprises Minister Pravin Gordhan says his legal team is scrutinizing the Public Protector's latest report and preparing an urgent review. Busisiwe Mkwhebane is once again accusing him of unethical conduct. She says Gordhan should not have allowed the so-called rogue unit at SARS to operate when he was commissioner there. But the former finance minister has stated that Mkwhebane continues to get the facts and the law wrong and is demonstrably biased. Well, Gordhan's lawyer, Tebogo Malachi, joins us now. Mr. Malachi, good evening. Thanks very much for your time. On what basis are you saying that the public protector gets the facts and the law wrong?
Good evening, to you and the viewers. We've obviously not had an opportunity to review the report. We've received it at about 4:30 this afternoon, much later than the news conference, and we are in the process of considering it. Now, what we've seen is obviously what was presented during the media briefing, and it is no different than what was put to Minister to comment about in terms of Section 7.9. We're not in a position to really say this, that, and the other aspect of the report is wrong in fact and law. What we can say to you is this. What we know is that unit was established as an investigation unit to combat the illicit economy. And secondly, what we know is that its capacity was created squarely under the tax legislation. And thirdly, what we also know is that when Minister was prosecuted for the same charges, or rather, when the Hawks were investigating the same charges, the then National Director of Public Prosecutions looked at the same set of facts, considered the same laws, and said there is no contravention. And we've put all of this to her, and we say she's gone wrong in terms of fact and law. There's nothing new presented to her office compared to what was presented to various authorities, including the Nugent Commission in last year and the NDPP in 2016. So we believe she has gotten it wrong, and we're in the process of considering that report.
You're also accusing her of bias. Tell us why.
Well, the manner in which this investigation has been conducted, and in particular, again, the speed with which it has been progressed, is of concern to us. So there are many things that during the course of the investigation we've requested of her office, and the responses have always been that we're being obstructive. To give you an example, we say this complaint is stale in terms of your legislation. Tell us why you believe it is worthy of special circumstances for you to consider it. And then we get told, given a generic set of reasons for it. And when we say there are people you say you've interviewed, could we have an opportunity to consider what they've said so that we can ask questions ourselves and make sure that all the relevant evidence is before you? We then get told no. Just put in your answer. We say minister has commitments. We need more time to respond. She says no. Respond by date X, which, by the way, we eventually met, and we've complied, which is minister's position is that office must be respected. It's a constitutional institution. And if she says comply by date X, you do so, and that we've done throughout the case. So the bias element, to our mind, relates to the manner in which we have been treated during the investigation, and that will eventually come out in the review court application.
Well, I mean, if from what the Public Protector's Office has said to us only a few minutes ago, it is actually your client who has been putting obstacles in the way of the investigation. The Public Protector's Office says your client kept on asking for extensions that they believe were not justified.
Well, let's start with the extension. There was only one request for an extension. And it's because the minister had commitments which took him out of the country. We asked for a particular time period. She refused. She gave us a shorter time period. We complied. We submitted on time. We had to do what we had to do in order to do so. So there is nothing if you look at the timeline of events, there is nothing in our conduct, either as his attorneys or either by him as the person who's being investigated, that would suggest that there was any delay or there was an intention not to comply with the request by her office. The record would display otherwise. And as I always say, the facts will ultimately speak for themselves. From our end, we feel aggrieved. To give you an example, she's now issued all sorts of remedial actions against the minister. We asked her for an opportunity to address her on those remedial actions that she may intend to ultimately impose. She refused. And we say that's unfair because when you look at those remedial actions, effectively, she's again directing the president and this time around the speaker to take steps which would ultimately result in the minister being removed from office.
May I ask,
unfair.
From what the Public Protector's Office told us earlier, Minister Gordhan was given an opportunity to interact with the Public Protector's intended findings. May I ask what your response was, or what you then said to her upon being given that opportunity?
We have responded in great detail. Firstly, to the factual, incorrect findings she intended to make, and we pointed out what the correct position was factually. And secondly, and in very elaborate terms, we explained to her how the intelligence legislation that she intends to rely upon for her findings is in fact of no application to this particular high-risk investigative unit that was established within SARS intended to tackle the illicit economy. In very great terms, we did so. And what we see, incidentally, is that exactly what she asked us, what she told us are her intended findings, and the eventual findings are the same, as though we haven't in fact made any submissions to her.
Now, you are preparing an urgent review, but the Public Protector warned earlier today, saying that, your review does not suspend the implementation of her remedial action.
Yes, we've learned of that. And in this instance, unlike the previous report, she has put timelines on that which the President must do, and that which the Speaker must do, and that which the Minister of State Security must do, and that which SARS, the Commissioner of SARS must do. And we are bringing the review application because we say she's gotten it wrong, fact and law. But what we are also contemplating is that given her standpoint, expressly stated in this briefing session, media briefing session, it may be necessary for Minister to consider whether he shouldn't approach a court to stay the implementation of the remedial action pending the outcome of a review. And we've always said that, most functionaries defer to the courts. Once a review process commences, the court is going to look into whether the report should stand or should be reviewed and set aside. So you would expect an incumbent of an office that exercises public power to say, all right, I'll defer to the court process. So we anticipate that she may do so, and if she doesn't, the minister may have no option but to approach the courts for a stay of the implementation of the remedial action pending the outcome of the review. The review is urgent in the sense that we intend to file it in the early days of next week. Minister is still out of the country. And then once launched, we're going to approach the office of the Judge President to say, this is a matter of public interest, national public interest. Can we have an expedited timetable for it to be heard and finalized?